Welcome to School Law, Part 3. Tonight we'll be talking about student rights. We'll start with the idea of student speech and expression. The First Amendment to the Constitution makes it clear. Congress shall make no law interfering with the freedom of speech. That has to be counterbalanced by the whole idea, as was put forth in several cases that dealt with the freedom of speech, with the idea of clear and present danger. School is certainly a place where free speech is allowed, and culture expression of student speech is something that school officials have to allow and respect. But at the same time, there is the notion, according to Justice Oliver Wendell Holmes, that the freedom of speech does not permit individuals the freedom to yell fire in a crowded theater. The idea of speech in school is further complemented because the school is an organ of the state and you're operating in loco parentis, in the fact that you serve in a role of parents with students who are minors. And so there is not an unbridled freedom of speech. The other component of that, established in several court cases, is the idea of material and substantial disruption. The idea that speech is not to materially or substantially disrupt the process of education. And where it does, schools have the right to intervene. The other element of First Amendment law that is significant is the idea of obscenity and uncivil discourse. Again, there is not an unbridled freedom to say or do anything you want without the consequences of the law. The Miller standard that was established in the 1970s set this standard up based on the overriding community standard. That case dealt with obscenity, but courts have typically rested with the idea that that freedom of speech does not allow individuals to participate in obscene or uncivil discourse. A couple of cases that we'll talk about as it relates to the freedom of speech, probably the landmark case, 1969, is Tinker versus Des Moines Independent School District. In that case, a group of students who were protesting the Vietnam War wore black armbands. The school tried to stop them from wearing those black armbands, and the students sued the school. The idea put forth in the case by the courts was that school officials did not possess absolute authority over students, and they are persons under the Constitution. Officials of the state could not deny the expression of students wearing armbands that did not constitute any kind of material and substantial disruption. That's where that standard came from. In 1986, Bethel versus Frazier, this case is actually a student's speech. It really set a standard to differentiate student speech different from adult public discourse. Students don't have the same freedom when it comes to speaking publicly in a school assembly that adults would have in a public assembly. The schools have the right to operate in loco parentis. The instructor's role in helping students learn was certainly a matter of this case in limiting the speech rights of that student. Morse versus Frederick, 2007. A student was wearing a shirt that says "Bong Hits for Jesus." The school confiscated the sign. I'm sorry, it was a sign, and the court backed up the right of a school to do that, to limit such speech. Once again, looking at the notion of obscenity and uncivil discourse. The last case is the Hazelwood versus Colmar case of 1988. This was a freedom of press case where the student newspaper had done a series of exposés on teen pregnancy in this school district in Missouri, and Colmar sued, claiming that was not. The editor of the paper, when the school said that was not appropriate and edited that and did not allow the publication, the bottom line in this case was that the Supreme Court sided with the school district, saying that the school district owned the press and that it was an instructive role. It was a co-curricular function in a journalism class. While the freedom of expression in Tinker came into play here, ultimately the freedom of the press resides with who owns the press. Other elements of free speech that are part of school issues are, of course, the threat of violence. In Doe versus Pulaski County, the idea of true threats beyond the protection of the First Amendment. This is a common occurrence now with social media, where students will threaten violence on others. And if these threats indeed are true, then they are beyond the protection of the First Amendment, and that is not a protected type of speech. We talked previously in our religion debate and lecture about public forums as they apply to school, the idea that there are different kinds of public forums: open public forums, limited public forums, and closed forums, and the schools can really participate in all of those, but mostly when it comes to use of facilities, as we've already previously discussed, schools cannot deny access, per the Lamb's Chapel case, the kind of speech that takes place in a school building when the facility is being used, if it is considered a limited public forum. The internet and free speech is another area that is a hot topic in the Reno versus ACLU case. The full speech protection for internet speech, there is not unlimited protection, particularly where that speech is disruptive and there is a spillover of that speech in the school, particularly if it's off campus. There are other cases where the internet, where students have made other threats on the internet and students have been suspended. In one case, the Wissanowski case, where a student threatened to fire a gun at a student or a teacher. The student was suspended, and the suspension was upheld because it was not responsible speech. Student personal appearance is another facet of speech. Regulations governing student personal appearance are valid where they're reasonable to maintain school decorum, prevent undue distractions which might interfere with the educational process. Of course, there's a lot of other dress code. The Kennedy case, where schools can apply dress codes, and those dress codes are not a violation of student First Amendment rights. We've discussed briefly the whole notion of the internet and off-campus speech. Mostly it's protected unless, again, it spills over into school and it's materially disruptive. The notion of fair comment and criticism versus threats. There are some cases out there where students will put together Twitter accounts or MySpace accounts that will make fun of teachers, will criticize teachers. Most of those are protected speech. Students have the right to that fair comment and criticism, particularly when it is not threatening. Page 63 of your textbook has a very important section that is important for everyone to read about FERPA and what FERPA is and what constitutes the Family Educational Rights and Privacy Act. This is something that school administrators have to deal with, particularly the idea of what records parents have the right to and others have the right to, and the difference between directory information and information that's protected by FERPA. Directory information is information that schools are provided or required to provide to the media and yearly notice to parents. Of course, many of you are also familiar with the notion of those records that must be retained and kept private. So please take a look at page 63. That is something that is definitely important for future school administrators to learn. Um, Talk briefly about search and seizure. Search and seizure is also something that is a very important component for school leaders and school administrators. The Fourth Amendment to the Constitution and the Due Process Clause of the Fourth Amendment prevent inappropriate search and seizure. The key case here is the Ohio case. It links the Fourth and the 14th Amendments together. The Fourth Amendment, remember, like the previous Bill of Rights, applied only to the national government, and the 14th Amendment, when it was passed after the Civil War, applied all those Bill of Rights amendments, those 10 amendments, to state governments as well. The idea of protection against arbitrary search and seizure by the government without due process of law. The exclusionary rule is also a component of this, and that is the exclusion of illegally obtained evidence. If you obtain evidence with an improper search, it is excluded from any evidence in a court of law. Public school searches, the main standard to remember here is if you were an adult looking for a regular search, it's probable cause. In a school, it's reasonable suspicion. The question here is the whole reasonableness and the randomness of these searches. The cases that we will discuss here regarding search and seizure is New Jersey versus TLO, 1985. This is the notion that the Fourth Amendment applies. Reasonableness of search, which establishes the notion of not probable cause, but reasonable suspicion. So school officials, they are not representatives of the states. They are more representative of a parent. And the court actually says they're representing both the state and the parent. So that's a very difficult line to tread in representing the state and representing parents. The idea then allowing schools latitude to maintain an orderly school environment by allowing reasonable searches and even random searches. So the Veronica v. Acton case in 1995 is where we get into this randomness idea, and that is urinalysis testing for athletes and trying to identify drug issues. This is, again, where you get into the role of the school, parent versus state, the rights of the student, and the whole notion of privacy. The standard that was set in this case was the non-evasiveness, the fact that these were students involved in extracurricular activities, and the fact that this is a random type of search situation. The other case here is the Board of Education, the Independent School District of Pottawatomie County versus Earls in 2002. And this is the idea that all testing, non-violation of the Fourth Amendment, giving great latitude in allowing school districts to maintain safety and order. So generally the law is on the side of school districts. Couple of real important standards. First of all, on a field trip situation, you're again off of school, but it's good always to have written policy, supervised environment, under the supervision of public school staff. You can search. Lockers, you can search, particularly if the policy is there. The lockers are school property, and so there's a lot of latitude. Metal detectors, when it comes to randomness, is considered to be minimally intrusive and generally legal. The one area that is where randomness does sort of meet a very difficult standard, and that is classroom searches, where you just go in a classroom and randomly pick somebody's belongings and begin searching them without any reasonable suspicion. That is dicey and has typically been not supported. Drug dogs are considered not constitutional Um, although if they're applied to everyone and not random to just select individuals, they can be permissible. So you have to be very, very careful with random issues. Car searches, again, reasonable suspicion is the standard. Random searches are problematic. Um, it's also important um, as you deal with school resource officers. They are sworn law officers, and it's really important that the standard that they have to uphold is a standard of probable cause, not reasonable suspicion. So it's important that when you're in a search situation that your school officials, your school employees are the ones that are doing this, not the law officer. They don't need to be involved in that kind of thing. There will be a case that is put up that is actually a case that involved my district, the Owensboro Public School, and that is a cell phone search case involving this district prior to my term as superintendent. And again, the courts, this is an area where the courts really haven't completely ruled, but generally you have to be very careful in picking a cell phone up and just searching it randomly. Even if you have reasonable suspicion, there's some privacy concerns with doing cell phone searches. So that is a really important case and a really important area where the law hasn't been very clear yet. Lastly, we want to talk about student due process protections. And again, this notion of reasonableness, and in loco parentis, it's the notion of the state and the ability of you as a representative of the state in trying to organize a well-run and well-ordered school, a fair school, a just school, but also working in the role of the parent. And again, that's a very difficult line. The Fifth Amendment and the 14th Amendment are the constitutional provisions here. The Fifth Amendment provides due process of law. The 14th Amendment, again, makes that applicable to states as well as the federal government. This notion of the doctrine of vagueness with constitutional due process is that the state may deprive a person of life, liberty, or property as long as they follow due process procedures. This notion of procedural due process, this is the notion of following procedures, of offering a fair hearing, prescribing a constitutional procedure of how to go forth. Substantive due process is the notion of fairness, adequate notice, consistent standards, rational, legitimate purpose, and it's applied equitably across all groups. So you have to look at both the procedural due process and making sure you're following procedures, but also substantive due process, which is that you are acting fairly and consistently and rationally according to equity and justice. The case here is Dixon v. Alabama and Goss v. Lopez. Dixon is a procedural due process for a student that was expelled. The school district didn't follow procedures. The student didn't. The court did not uphold the expulsion. The Goss case is a due process case for a temporary suspension. The notion, of depriving education for 10 days, and the issue of substantive due process. Sometimes it's the fact that it is consistent and not rational or legitimate, and that's what the court found in the Goss case as you read it. The Eighth Amendment is the notion of cruel and unusual punishments. Ingram v. Wright, 1977, is the corporal punishment. It is not considered cruel and unusual, although I think you see very few school districts ascribe to this anymore. The notion of zero tolerance, the idea of mandatory sentencing, that if you do something without any question if you did it, then you must follow these rules. That is generally upheld, even though it's not necessarily considered to be that effective. It is generally upheld in the court of law. Child abuse reporting violations and requirements and liabilities. You need to know that as a school administrator, If you know about certain circumstances, you have an obligation by law to report that. Title IX, we talked about briefly this notion of gender discrimination, sexual harassment, the Davis decision, this notion student on student sexual harassment, if you know about that and you don't report it. So that's important from standpoint of understanding if that is happening in your school, you have an obligation, and if you do not and you know about it, you could be held liable for it. And then this notion of deliberate indifference to discrimination, and that's this whole notion of of knowing that this is going on but being indifferent to it. Again, understand this from the standpoint of bullying, and dealing with issues when it comes to LGBT sexual orientation and harassment issues, child online privacy and the whole Protection Act when it comes to children using the internet, and of course this notion of dating violence, sexting, and child pornography. Those are all things that schools have an obligation, if you find these things out and you know about them, to not be deliberately indifferent, but to be more actively involved in trying to do everything to prohibit that. That concludes our session, part 3 for student rights.